This week, the Prime Minister seemed to suggest that offenders could be both punished and rehabilitated, reflecting speeches by two of his ministers at the Conservative Party conference. First, punishment. This is the reform promised by the Justice Secretary, Chris Grayling.
It's called 2 strikes and you're out. So if you commit 2 serious, violent or sexual offences, you will get an automatic life sentence.
That sentence has already been approved by Parliament. What Chris Grayling is telling us is that it's about to come into force in England and Wales, though I'm not quite sure when. And it may ring a few bells. Do you remember in the late 1990s the Conservative Home Secretary, Michael Howard, introducing mandatory minimum sentences for a third drugs offence or a third domestic burglary? That was called 3 strikes and you're out. It doesn't seem to have made very much difference, perhaps because it gives the judges some leeway. But so does the new law. Julian Roberts, Oxford University Professor of Criminology, is a member of the Sentencing Council. Is Mr. Grayling right to say that a second serious violent or sexual offence will attract an automatic life sentence?
Well, it's certainly mandatory. The legislation states that a court must impose the sentence if the criteria are fulfilled, although there is some residual judicial discretion to impose a lesser sentence in the event that the mandatory sentence would be unjust in all the circumstances.
Of course, we're talking about quite serious cases, so the judges may have no difficulty with imposing a life sentence in the sort of very serious cases we're talking about.
But let's take a practical example. An offender who is convicted of rape, for example, who might attract a 9-year sentence, that's typical for rape. 10 years later, he commits another serious offence of that nature. A court would then impose a much longer sentence than another 9 or 10 years. So these offenders would at the present time attract a very long custodial sentence.
I suppose the difference is that if they want to get out, then they've got to, persuade the parole board that it's safe for them to be released?
Indeed, and that will require them to take steps and to follow courses and so on, rehabilitate themselves.
Are we right to feel that this sentence is going to give us greater protection against very serious offenders?
Absent some compelling new evidence from the government, I'm not sure we can be confident it will offer additional protection. These offenders tend to be older offenders. Their risk declines as they get older, and so you end up having an ageing and large offender population which may not pose the risk that gave rise to the provision in the first place.
Professor Julian Roberts suggesting that 2 strikes and you're out will have as little impact as the 3 strikes law that preceded it. The other announcement at the Tory conference that I want to look at came from the Home Secretary, Theresa May.
We will change the law. So when a criminal receives an out-of-court community punishment, the victim will be given the power to choose the form it takes. For too long, victims of crime have had no voice. But this government is giving victims back their voice.
Theresa May promising to give victims back their voice. That suggests victims have lost a say in sentencing, which they once had. Is that right? Professor Julian Roberts has carried out research on victims' attitudes.
Well, victims have had some input into sentencing since 2001 in England and Wales through the Victim Personal Statement Scheme, by which they can depose a statement, one of the primary purposes of which is to describe the harm of the offence and the consequences for the victim and the victim's family, and a court can then consider that at sentencing.
But now, Theresa May says the victim will be given the power to choose the form that the community punishment will take. They may want something restorative or punitive. So this is something of a change.
Yes, so this sets it apart from the victim personal statement regime, for example. Now we're talking about some input into the actual consequence for the offender. It's not clear to me that victims have asked for input into the exact nature of the consequences or the sentence that will be imposed. The other worry would be that it's going to create more inconsistency across the country in terms of the extent to which victims have this input, the options that are available to victims in terms of the options that will be imposed upon the offender, and so on.
The academic criminologist Julian Roberts, not very impressed by the Home Secretary's announcement either. What about victim support, the organisation that helps victims and campaigns on their behalf? Adam Pemberton is an Assistant Chief Executive with Victim Support.
I think it's welcome to give victims a greater voice and a greater sense of a stake in sentencing. We need to see the detail of the proposals and how it would actually work.
Will all victims want this, though?
No, I don't think so, and I think that's a really important point to look at when the proposals are published in more detail, because what victims will say is they would like the opportunity but not the requirement to be involved. It needs to be driven by the victims, and I think in the past some community sentencing has been more driven by the needs of the offender or what's right for the offender rather than what's right for the victim.
Adam Pemberton. To see how these proposals are likely to work in practice, I was joined in the studio by Michael Turner QC, who heads the organisation that represents barristers working in the criminal courts, and by Robert Buckland MP, a barrister, part-time judge and Conservative member of the Commons Justice Committee. Robert Buckland began by pointing out that the 2 strikes and you're out sentence will replace the current system of indefinite sentences for some offenders.
Well, it replaces the existing legislation on indeterminate sentences for public protection, IPPs as we call them. It's a much needed replacement in my view. But the important distinction between these proposals and the previous regime is that it gives a greater degree of certainty, I think, not just to those involved in the system, but to the victim of the offence. One of the problems with IPPs was that really there was no certainty for the victim as to when, if ever, the offender was to be released.
Michael Turner, what do you think of this proposal?
Well, this and the other proposal we're discussing today have the air of populist ideas which have been designed on the back of a fag packet. It's a shame that our politicians seem incapable of learning the lessons of even very recent history. IPPs were shredded in Europe.
You mean the European Court of Human Rights decided that they were inconsistent with the Human Rights Convention?
Correct. And the same is likely to happen with this piece of legislation, in my view. It's a very blunt instrument which is designed to remove judicial discretion.
But there is discretion, though.
Yeah, there is a little bit of discretion. It's got to be unjust, is the wording of the Act, in order to be not imposed, and that puts the onus on the defendant. It seems to me to actually prove that.
Isn't the position, though, that somebody who is convicted of 2 serious offences of this sort would probably get pretty long sentences for 2 offences like this, a longer one for the second, and you'd be serving pretty much the equivalent of a life sentence?
That is certainly possible in an individual case. But what this does, this is prescriptive sentencing by politicians, which in my view is a bad idea. It is likely to lead to injustice. No 2 crimes are the same. The court has got to be allowed to maintain a discretion. I don't believe this piece of legislation gives them sufficient discretion to give effect to personal mitigation.
Robert Buckland?
Michael's being rather unfair about these provisions. This type of approach is not new. I think it's infinitely preferable to the open-ended system of IPPs.
But although you've abolished IPPs, there are still people serving these indefinite sentences, and as far as I can see, they're not going to be let out because there aren't enough probation officers to see whether they are sufficiently rehabilitated.
Well, Joshua, that's one of the important points here we mustn't forget. This is a life sentence, but with an opportunity of parole. And one of the problems with the IPP system, as we saw, was that there could be no proper planning within the prison estate to manage those on IPPs, because, frankly, it was an open-ended system.
So isn't that better, Michael Turner, than the existing system?
It's possibly better than IPPs, which was a dreadful system. But we started off with 3 strikes. We went to IPPs. We're now on to 2 strikes and you're out. Robert knows that our prison system is absolutely creaking. The ability to do anything useful with prisoners is virtually nil now. The prison governors are complaining about the ability they have to properly help and educate prisoners and rehabilitate them.
Let me move on to another proposal that the government announced at the Conservative Party conference, and that was the Home Secretary's idea that where a criminal receives an out-of-court community punishment, the victim will be given the power to choose the form it takes. And Theresa May said that the government is giving victims back their voice. I didn't think that victims used to have a voice, Robert Buckland, but tell me what the government's seeking to do there.
Well, this, I think, is a welcome development, and it really relates to the system of cautioning. Instead of just admonishing or cautioning an individual, that person is invited to actually make some reparation to the community. And it's then at that stage that the community can become involved by choosing from a menu of options the type of reparation that would be appropriate. It's very much in line with the sort of restorative justice principles that I've been advocating so strongly in Parliament. And I think it chimes very well indeed with a sense that for many crimes that are sometimes described as low level, they have a real impact in our communities, affect well-being and cause real misery to thousands of people.
But Robert Buckland, why would the victim have any idea what the best punishment for the offender is, and why should the victim even be invited to choose, let alone have to choose?
I'm not pretending that the victim's voice should be the sole arbiter. I don't want some sort of Anglo-Saxon form of justice. What I want to see is the victim's voice as part of the mix, and particularly appropriately in a scenario such as this, where we're dealing with communities.
Michael Turner, should we be giving victims back their voice, or are we returning to Anglo-Saxon style punishment?
Well, I think giving victims a say in the sentencing of individual defenders is a very, very dangerous wedge indeed. Sentencing is required to be proportionate and there should be parity. This proposal creates a situation where different punishments will be set for the same offence. It will certainly be susceptible to challenge under the Human Rights Act, in my view.
Why is that?
Well, I think that what you're going to have is where a victim demands what some will say is an unfair and unreasonable punishment because they're sending them to grant them to do their community service in order to clean out the sewers, whereas another victim is allowed to go and work in the tea shop round the corner. That is going to be a problem. And where is it going to stop? Are we going to get victims given the right to say how long their prison sentences should be?
Michael, this isn't the same as a sentencing process. If I'll call him the wrongdoer at this stage because he's not a defendant, doesn't accept the conditions, he's free to do, or she is free to do that. There may be consequences that follow in the form of formal court proceedings, but this isn't an imposition. This goes with very, very much by the principle of consent, and I think that's why human rights challenges, I think, do not loom as large as they would do in a more formal proceeding.
Michael Turner, you have to take your victim as you find him, and if one particular victim happens to be worse affected by some minor piece of graffiti or whatever else it is that's produced the community punishment, then surely it's right that the offender should receive a more severe or at least a more unpleasant punishment.
Yes, we have a court system that does that. We have a court system that tries to get it right across a whole band of spectrum of offences and tries to make sure that there is parity. This is not going to produce parity. My other fear is that it's going to be completely unworkable and victims will be given a right that in reality will never be properly used.
Michael Turner QC, Chairman of the Criminal Bar Association, and the Conservative MP Robert Buckland, alerting us to the law of unintended consequences.